And we're back. This is Josh Jelinski, the financial quarterback, talking to Greg Racki. Folks, if you miss an episode, you can check us out on the iHeartRadio app, also Spotify, and WOR710.com. So, Greg, answer the age-old question. For those just joining us, I pulled Greg's arm, got him to agree to a 2-for-1 special today, 888-988-JOSH. Get a consult with an estate planning attorney for free. I mean, attorneys charge a lot of money usually, so this is a good tip. Don't waste his time completely, but you get a 2-for-1 special if you call our office at 888-988-JOSH today, 888-988-5674. So anyway, so Greg, how do you resolve that? I have my own answer, but I want to hear your answer first.
I think generally it's dependent on your individual family situation. If the person that you think would be best to manage your children, to raise your kids, to take them to school, to cook them dinner, to do all of those parent things, are also people who are good at managing money, I think it's just fine to make them the same. I think by making the trustee the same person as the guardian, you're avoiding potential tension between a different trustee and the guardian. You have the kids, you know the needs. It might be awkward to have to go to your wife, your dead brother's sister-in-law, who's the trustee on the other side, to say, okay, I need $5,000 this month to pay for summer camp or whatever it is.
But I like that idea.
People with the kids.
I have 7 kids.
A lot of people do.
So maybe, okay, so here's the thing. Let's say my sister-in-law gets the kids. Although she's not really volunteered. We had a good friend, by the way. This is a point. I have 7 kids. Who the heck wants 7 kids added to their 2?
That's a lot of kids, Josh.
Greg, do you want to be the guardian of my children?
No, there's too many of them.
Thank you for your honesty. We have a dear friend. They have 5 kids. They will gladly take our 7. That's very nice of them. They volunteered. But, so this is a major, so I'm going to get a lot of free estate planning advice this hour too. Although we're not giving any legal or tax advice, nothing we say can be construed as that. Legal, tax, or financial advice, or whatever the disclaimer is. But for me, definitely money and kids have to be separate because it's so convoluted with 7 kids. So for me, I want to keep the money separate because, like, I have my sister, I have my other sister, I have my brother. I love my siblings dearly. I don't really think they're going to take my kids. Although they would if, like, they were orphans and nobody wanted them. But my sister's already raised 4 kids. My brother's raised his daughter. You have, it just, I don't see it happening, Yeah. So what I've thought was like, okay, my side might be the trustee, so then they can dole out the cash to the other side, but at least then my side, like I can put, can I put a stipulation that the other people, let's say the friends who take the kids, that they have to bring them to the 2 sets of family members or else they can't get money to take care of the kids? Something like that?
But well, first let me say your position is, I think, also very popular. This is why it's a classic debate in estate planning. I think there are good arguments on both sides.
Yeah, your side makes sense. I just mean for my side is weird. I mean, I have 7 kids. Who has 7 kids today? People look at us like we're freaks. We're like a freak show. Everybody always stares at us. We're a bunch of beautiful, not me, but my children are beautiful blonde-haired kids. My wife's beautiful. So, like, they stick out like sore thumbs. They're all these like towheads. And we're like, hey, it's rude how people are though with us. But anyway, people just staring. Like,
I'll be friendly if I see you on the street.
And it's no lie. Like when we had 4 kids, okay, it's cute. 5, great. We started at 6, people giving real looks. 7 looks like it's amazing how our culture today really has a weird view on kids. But anyway, kids are a blessing. But hey, I mean, it's a lot of work. Don't get me wrong. But it's funny. So not everybody would take 7 kids, right? So
yeah.
But then let's say like both sets, like my wife's side and my side, they don't take our kids, and one set does. But we still want them to have a connection to both family members. Can I put some stipulation that the guardian doesn't get any money to take care of the kids unless they have a once a year visit or once a month visit to family or something? That way they still stay connected.
It's a good point. I have a solution, but let me give you a little more background information of why this is a little more tricky than you think. First,
this is good. You know what, Greg? I really like you. You know why? You're giving some solutions. Some people, they come on, they play very coy, and I like you. So go ahead.
Happy to give answers. So on the guardianship side, there's the same rule in Massachusetts as it is in New York, is that when you're actually making out a will and you're nominating a guardian, you're just nominating the guardian. The legal standard in Massachusetts and New York, and as far as I know, every state, is that the kids are going to go to in whatever the judge decides is in their best interest. So best interest of the child, or 7 children, is going to be the legal standard. And there's a presumption that whatever the will says that the parent wrote is what's best for the kids. Now, some people come to me, and I know this wasn't your question, but it's related, and say, well, I want my brother to be the guardian, but I wanted to say directly in those papers that he's only the guardian if he lets my wife's sister also see the kids twice a year.
Yeah, stuff like that. Yeah.
Yeah, you can't do it on the guardianship side. The court's going to name someone guardian, and that's just going to be it. That person's going to be the guardian. The court is not going to set up a situation of shared custody or mandatory visitation. I've never seen that only in divorce, not on death. Now, on your actual question is on the trust side. So on the trust side, can you say, okay, one sibling or one person is going to be the guardian, but the money cannot be used for the care of the children. It cannot be given to them for the care of the children unless there's visitation on the other side. You'd be putting the trustee of that trust in a tough situation, because the trustee's job is based on the fiduciary standard to do what's in the best interest of the beneficiaries. Now, what's in the best interest of the beneficiaries is to get money for those kids, even if they are not seeing their siblings on the other side. So to put that sort of stipulation in there is to put the trustee in a tough position where they're going to actually withhold funds from a beneficiary that might need the money because that beneficiary's guardian, who's not the trustee, is not allowing for visitation. I wouldn't want to be a trustee of that trust because of the conflict that would be inherent there. Now, I do have a solution. What I actually see pretty often, and I draft for clients, is
here's the thing. Why wouldn't you, if I was giving you 20 grand a year, I don't know, 20 grand a month, not 20 grand a year. I'm going to give you 20 to 30 grand a month to be the guardian of my children.
Yeah.
Why wouldn't you take them to see both sides once a quarter?
Well, I think you should. I think you're a jerk if you don't. But
that's the other tip, by the way. If you agree to be somebody's guardian, make sure they have life insurance to take care of those kids, or don't agree.
Yeah.
Because that's something I've seen. And you don't even have $1 million term policy, and you're expecting these people to take care of your kids, and you weren't really responsible. So that's a good tip.
There should be sufficient assets, yeah.
So if I'm giving you 20, 30 grand a month, you're going to find it too difficult to go visit my brother and sister once a quarter?
No, I think these people certainly should comply with that request. And it's probably what's in the best interest of the children is to see their extended family. But the question is, what can you compel in the trust provisions? And can you force that, or can that trustee be forced essentially to, or have the option to not make distributions that benefit the children because it's something that the guardian was doing? So what is often done is you have a letter that you write in no uncertain terms to the trustee saying that you expect that the trust funds will be used so that both sides of the family can be visited. Not only are you saying that you want both sides to be visited, but you're saying the trust funds in particular got to be used for that purpose. Now, that's not binding, but at least prevents that awkward conflict the trustee.
How do you make it binding, or you really can't? Well, wait. We'll be back with the exciting conclusion of this segment when we return. So, folks, this is good. We're getting some good, valuable tips. We're talking estate planning, capital gains, what to do if you have 7 kids, but it's really 2 kids, 4 kids. if you have 2 or if you have 7, it's like a fight. Like, what am I going to do with this person? Greg, you probably have that with your spouse, right? Like, what are we going to do with the kids? Was that a fight for you?
It was not a fight for us. It was not. We had some pretty clear options. We have some good options. We're very fortunate.
Oh, well, that's nice. That's the politically correct thing to say.
I have some good spouse fight stories. Spouse fight stories should be a topic here too.
That'll be a segment next. When we return, this is Josh Jelinski, the financial quarterback, and call us at 888-988-JOSH if you want the free 45-minute wealth blueprint, and we'll throw in a meeting with Greg Racki. Great guest, by the way, great estate planning attorney. We've had a bunch of estate planning attorneys this year, and you seem very approachable, and your tips are a little more tangible than what some people give. So I love it. When we return, this is Josh Jelinski, the financial quarterback. Call us at 888-988-JOSH, 888-988-JOSH for the free 45-minute wealth blueprint. And Greg Racki will give you a free consult. Next, 888-988-JOSH. Okay, and we're back. This is Josh Jelinski, the financial quarterback. I can't speak lately. I don't know. I think it was a side effect of COVID. I had COVID like 3-4 weeks ago. It was a great segment on last week's program, me talking about COVID. Everybody's like, I'm getting emails. Are you all right? Are you going to die? I have a doctor for you. Take some ivermectin. I have some quercetin. I have some zinc, D. Folks, I took quercetin. I took D. I take zinc every day. Didn't help. Still got COVID. So anyway, so we'll leave it at that. But it was rough. I'm a fairly young man. I can't talk, and I'm a little bit like charred in my throat. So, Greg, let's. So what's your resolution to this guardian thing? Is it like a letter of a testimony or something? What do I do with my kids?
I think that the best way to do it is to put it, if you feel really strongly about it, it sounds like you do, and maybe some of your callers do, or some of your clients do in similar circumstances. I think the best you can do is put it in a strongly worded letter that you expect the trust funds to be used to see the children, and also put it directly in the trust, that the expectation is that the trustees, and if that's the same person, the trustees will be granted visitation, and that the grantor, without creating any enforceable rights or duties, expresses his or her wish that the trust funds are used for visitation of both sides of the family. And feel free to massage that language to your individual situation. Name these individuals, say twice a year, say at the family retreat in Vermont, whatever it's going to be. But I would put it in a side letter and put it as non-binding language in the trust.
But could I put it in binding if I wanted to? Could I make it binding?
I don't. You could make it binding. Let me be clear.
You could make it binding, but you would not want to be the trustee, because then you would.
Exactly.
So I would have to not pick you as the guardian. Well, it really would be the guardian, because the trustee would then dole the money out, right?
True.
You could be the trustee, not
the guardians. Yeah.
Is it?
And the guardians have the right to look at the trust on behalf of the minor children. So the guardian could, if they were savvy enough, know what strings are attached to the purse before they decided to come on as guardian. So, again, you could make that binding. The guardian might have something to say about it if they didn't want to give that visitation, and the trustee might have something to say about it because of the potential for a conflict between holding money from the beneficiary. You're not giving it to the guardian, but you're really not giving it to the beneficiary for visitation. So, if you can find people that will play ball by these rules, then go ahead. I wouldn't want to be the guardian or trustee, just to be clear.
Okay. So you're out then. You're not going to be the trustee of my children.
Money from me anyway. So yes, I was out with the 7 kids. I don't care what's in the
No, but here's the thing though. If you have 7 kids, right? Maybe you want to take care of them if you're going to get a good salary every year, right? As the guardian.
Yeah.
That's another solution for life insurance. That's why I have a lot of life insurance, because then people want to be the guardian of my kids because they're going to get paid for it.
Yeah, you're entitled to reasonable compensation in the absence of a term that says you can't be compensated. So reasonable compensation can be pretty hefty. I would want a lot of compensation for
So let's say, is there a fight? That's a good point. Okay, so let's say we have a listener who dies and leaves 2 kids to you. But in the will, or let's say it was a $2 million life insurance policy, it goes to the wife and then it goes to the kids.
Yep.
How do you as the guardian get the money to that when it's really supposed to go to the kids or whatever? Or you can make a claim to a court.
I'm sorry, I'm not sure.
So you said the guardian was entitled, guardian's entitled reasonable compensation. Let's say it's a young couple, they leave $2 million of term life insurance to each other, but they both die in a car accident. So then it goes to the kids. You're now taking care of the kids, but you're not stipulated in the will. You're not stipulated. You're named the guardian because they were your best friend's kids or something, and you want to take them in. They only have 2 kids. They don't have 7. So you and your wife say, "Well, we'll take 2," and then, but they don't leave any stipulations, and so the $2 million goes to the kids 2 different ways, 50-50. They have 2 kids.
Yeah.
How do you get money as the guardian when it goes to those kids?
So to be clear, the trustee of a trust and the executor of an estate, the person representative of an estate in Massachusetts, is entitled to reasonable compensation. Interestingly, guardians are not entitled to compensation. However, what people often do, it's one of the reasons people consider making the trustees the same as the guardians, so they can use that operation of law to be entitled to compensation. That's really for both roles, as trustee and as guardian. But sometimes what people will do if they don't want them to be the same individual, if they want separate trustees and guardians, is we'll stipulate that the guardian is entitled to a gift from the trust of $20,000 a year. Also, if you're the guardian of children who are beneficiaries of a $2.5 million trust, that money is going to be coming to you, and this has been litigated. You are allowed to use that money for things that would enrich you, like increasing the size of your house, and you don't need to give the kids the increase in the capital value of your house when they turn 18. You just got to add the bedroom with the trust money, and that's just a nicer house that you have now. So there is an indirect way to benefit guardians, or you can directly benefit them by
because I've seen people over the years, and they're living like a pauper, and they're like, well, I'm raising my sister's kid, and we have this $200,000 for college. So then the kid has paid for college, but then the whole family's struggling for years, and and I thought something could be done about that. So that's good. So if you're in that boat, call us 888-988-JOSH. Greg will help you figure out a way to get some money.
Solutions.
So you can add some square footage to your house. No, but I really have seen that. People they live very simply, taking care of their kids, and then that kid's going to like Harvard, and then their kid's going to community college because they slaved away. Yeah. I've seen that over the years, not a ton of times, but enough to be like, so you have the dutiful guardian who kind of doesn't take any proceeds, but that would be a reason to make the guardian, the trustee, the same person, so they could take a little compensation. So that would be a ball in your court. But yeah, there's no one right answer. It depends on who you have, right? No. It's also for simplicity's sake. This is what I've seen sometimes with significant estates. I don't want your take on this. Sometimes everybody says, I want a committee, right? So you have the attorney, the accountant, the financial advisor, but then nobody agrees, nobody fights. Everybody starts fighting. There's turf wars. How do you resolve that? So let's say you have a client, they leave whatever, $10 million to an estate or whatever, a trust, and there's an attorney, there's an accountant, there's an advisor, there's a turf war. How do you resolve that? I've seen that more and more, like turf wars, because like you said, the trust company wants their fee, the financial advisor wants their fee, the attorney wants their fee, and then it's like, how do you win? How do you resolve that?
Well, ultimately, the trustee, if there's multiple trustees, usually what the trusts say is majority rules. So if you have 3 trustees, there needs to be 2 out of 3 voting. If there's just one trustee and there's a whole bunch of basically employees or people who are being paid by the trust, well, then it's just the trustee's job to hire and fire people to make decisions, because ultimately we're just the hired help. The accountants, the financial advisors, the lawyers all just work for the trustee. But if you've named all those people trustee, then you have a real committee where people have real power and can have control over the trust. That can be more difficult. Another reason to be careful with who you name as the trustee, because you're giving them a lot of discretion. The trustee is the boss of all of the hired help, all of these professionals.
So what about naming? We had one guy on, I don't know if it was Blockmacher, one of these guys who's like a heavy hitter in the estate planning world. It wasn't Blockmacher, it was another guy. And he talks about naming a financial advisor to the trust. What is that? So can someone have a trustee? Because I generally don't like the financial advisor to be the trustee because there's a conflict of interest there. But let's say you want that financial advisor to help the affairs through your demise and help your estate, but you don't want to have a conflict. So your trustees, let's say the attorney, but you want to name the financial advisor so the attorney can't fire the financial advisor. Is that allowable? I've heard some people talk about that, the financial advisor to the trust. We will be back with that cliffhanger when we return. And folks, 888-988-JOSH. Give us a call right now, 888-988-5674. When we return, we'll be back with the exciting conclusion. And call us at 888-988-JOSH for our 2-for-1 special today, a 45-minute ultimate financial game plan where you get an income for life report that shows you how to live off your assets. We'll also go over tax planning strategies and estate planning strategies, where Greg has been so gracious to offer a free consult to those of you who want one at 888-988-JOSH. Call us now, 888-988-5674. We'll be back after these messages.
The preceding program was sponsored by the Jelinski Advisory Group.
Any awards, rankings, or recognition by unaffiliated third parties or publications, including 5-Star Wealth Manager, Advisory of the Year finalist by Senior Market Advisor, and top of the $1 Million Roundtable, are in no way indicative of the advisor's future performance or any individual client's investment success. No award, ranking, or recognition should be construed as a current or past endorsement of Josh Jelinski or Wealth Quarterback LLC. Information regarding specific awards, rankings, or recognitions is available on the Wealth Quarterback website at www.jelinski.org. All investment strategies have the potential for profit or loss. Investment strategies such as asset allocation, diversification, or rebalancing do not assure or guarantee better performance and cannot eliminate the risk of investment losses. There are no guarantees that a portfolio employing these or any other strategy will outperform a portfolio that does not engage in such strategies. This broadcast should not be construed by any client or prospective client as a solicitation to effect or attempt to affect transactions in securities or the rendering of personalized investment advice. Due to various factors, including changing market conditions, the information discussed in this broadcast may no longer be reflective of current positions or recommendations. While information presented is believed to be factual and up to date, Josh Jelinski and Wealth Quarterback do not guarantee its accuracy, and it should not be regarded as a complete analysis of the subjects discussed. The tax and estate planning information discussed is general in nature, is provided for informational purposes only, and should not be construed as legal or tax advice. Listeners should consult an attorney or tax professional regarding their specific legal or tax situation. Advisory services offered through Wealth Quarterback LLC.